This conference will now be recorded.
All right, so welcome everybody. Thank you for joining me on what's going to be our last Friday of the new month of January 2024. I'm excited and I hope to motivate all of you today to either update your existing estate plans, or perhaps you're looking to fill in things that you don't have, or create an entirely new estate plan. So we're going to cover a variety of topics today for people who have plans, don't have plans, might be single, married, or perhaps divorced, and how all those different situations affects the estate plan that we create. So I'd like to start our discussion today talking about when should we revisit or update our estate plan. And so if we think about certain life events that are major life events, that's to me a sign that we should revisit, take it out of the drawer, dust it off, read it, and ask ourselves, does this still help me meet my goals, or have my goals changed? So for example, if we are newly married or remarried, if we are divorced, if there's a new birth or a death in the family or among the beneficiaries we've named, it's a great time to reevaluate what we've done. If there are changes in the law and you work closely with me, I'm going to update you on what those changes are and how I think they might impact your plan. Another good opportunity to reassess what we've done is if somebody we've named and given a responsibility to in our legal documents, we call that person a fiduciary. For example, it could be our personal representative, our trustee, our power of attorney, our healthcare decision maker. If they have become sick or incapacitated, or perhaps unexpectedly passed away, that's another sign that we might need to update our plan so we have another alternate in our toolbox. Remember, it's very important to not just name one person in these various roles. We want to have at least one, if not two alternates. So if something unexpected happens, like the person we name can no longer take on that role, we have somebody else waiting as a standby. Now, another time we want to reassess our estate plan is if we have a change in financial circumstance. What would this be? This could be that somebody has left you an inheritance. It could be that you picked the right numbers Saturday night for the lottery and you've won money. Or it could be that you had a lawsuit that has settled. So those are all good times to reassess what we've done, because there might be some tax implications we need to think about. So think of updating your documents the way we approach taking care, I hope we take care of our health, which is at least go for a checkup once a year. It's that idea of preventive maintenance. Let's spot things before those issues become problems. So let's start talking about what we should be thinking about when we have a spouse, or perhaps we're divorced and now we remarry. Well, one of the things we're going to touch on in a little while is the fact that Florida has a law that protects a surviving spouse in a marriage when one spouse passes. And how it protects the spouse is to ensure that that surviving spouse is going to receive, at a minimum, 30% of the deceased spouse's assets. So if you want to leave less than that amount to your spouse, you do need to work that out. And how you do that is you would go to a family law attorney and have that attorney prepare either a prenuptial agreement that would be signed before the marriage, Or if you're already married, it will be a postnuptial agreement signed after the marriage, where both the spouses are agreeing either to waive their rights to inherit or they're agreeing to a lower sum or a lower percentage. Now, let's say you have an estate plan in place, now you're newly married. You want to update that. Why? Because it's very likely that plan you have refers to the former spouse. You don't want them to continue to make medical decisions or financial decisions. So you want to update your plan so your new spouse is named. And remember the importance of always having 1 to 2 alternate people named as the standby. So our plan is not going to fall apart if the person we named in the first position gets sick or passes unexpectedly. Now, what if a married couple has children who are under age 18? And in Florida, that's the age at which a minor becomes a recognized legal adult. Well, the thing to understand is that parents are called natural guardians, which means until 18, we can make our children's medical decisions. We can give informed consent to treatment. We can decide what school they're going to, where they're going to live. And we can make financial decisions if, let's say, grandma or grandpa left them an inheritance. But we want to also be thinking, as much as we don't want to think about mortality or illness, we have to think of the what if. What if something happens to me? What if I become incapacitated or pass when my children are under 18? So we want to think about naming a guardian who would step in and make the healthcare decisions for the child, make financial decisions for the child. And if I'm going to leave an inheritance for my child in a trust, I then need to select somebody to take on that responsibility as a trustee. Now, we mentioned a couple of minutes ago the importance of updating plans if people have gone through a divorce. Now, Florida's law actually says that once the court order is signed, holding that this couple are no longer married to each other, that automatically, if the spouse is named as a healthcare surrogate, a power of attorney in the documents, it's as if they predeceased. Now you might say, well, that's great. Since the law says that, why do I need to do anything? Well, the reason you want to update the documents is now that your ex-spouse is no longer recognized, what if you only named one alternate after your ex-spouse? That means you really don't have an alternate because the person in the second position has now moved up to the first position. So I do suggest you update your documents. It's a very clear way of sending that message. The ex-spouse is out of the picture. Now you're naming a new primary decision maker, and you're going to name several alternates. Now, if perhaps you didn't get divorced, but your spouse has passed away, and you are the surviving widow or widower, again, it's a good idea to revisit the document. Most likely you will have named your spouse who passed as the first decision maker. So you want to say to yourself, okay, is the second or third person I named still able to do that? Are they having any health issues? Are they encountering anything in their lives that might prevent them from still taking on the responsibility to help me when I need it? So it's still a good idea to revisit. Talk to the people that you've named as your fiduciaries. A lot can happen in 5, 10, or 15 years. We want your plan to work when you need it the most. And the way to make sure that you reach that goal is to reassess and to update. Now, you'll hear me mention what I call an incapacity plan. And it doesn't mean the same thing as what I call an estate plan. So an estate plan means we write a will, a last will and testament to pass on your assets, or we might write a revocable trust as another way of passing on your assets. That's your estate plan. Your incapacity plan, however, is meant to work while we are still alive. We might be in a car accident and perhaps temporarily disabled or incapacitated, or we might have a chronic or long-term illness. So when I say incapacity plan, it means we have documents in place, like our power of attorney, like our designation of healthcare surrogate, that gives people we trust, that we've placed our confidence in, to assist us during that time. That means we stay out of the court system. Nobody has to do a guardianship for us. And what are the benefits? Well, the benefits are we keep our privacy, our confidentiality, because our power of attorney document and the designation of healthcare surrogate isn't going to be filed anywhere. It's not a public record, so it stays private. So we are keeping the privacy in our lives, which I hope everybody's going to agree is really very important. Number two, the second benefit is it is going to be far more expensive to do a guardianship in court than it is to put these legal plans in place while we're healthy, while we're competent. We're going to lose that opportunity if we've already become incapacitated. Now let's talk about some tips, what I call best practices. And I would really love if everybody turned on their camera, even if it's for 30 seconds. And I'd like to see by a show of raised hands, how many of you think it is a good idea to leave a specific sum of money to people in your will or a trust? Go ahead and raise your hand if you agree with that. Okay, I see one brave soul, two brave souls. Anybody else want to turn on your camera and raise your hand? I see a third brave soul. Thank you. Anybody else want to weigh in? Okay, so how many of you don't think that leaving a specific sum of money is a good idea as opposed to using a percentage? Okay, I count one hand, two hands. We're almost at a tie here. Thank you. I see a third hand, a fourth hand. Okay, so let me give you a correct answer, and I'm going to tell you why it's the correct answer. The correct answer is it is better to use a percentage rather than a dollar amount, and here's why. The way a will is interpreted is the people that are named to first receive a specific sum of money, not necessarily from a certain source, are entitled. They have the priority to be paid first. So let's say a will leaves $5,000 to your favorite church, another $5,000 to the XYZ charity, and the remainder of what you own to your children. And let's say that at the time you pass away, there's not enough money left to take care of those two gifts and still cover giving something to your children. What happens? Well, because the will was written that way, the law says the charity and the church get paid up front. If there's nothing left, that means your children get zero. But we'll end up with the result you want if you use a percentage. So I'm going to take everybody back to high school math, algebra. Remember when the teacher used to draw the pie on the blackboard and we were learning fractions and the teacher would cut out a piece of the pie? With percentages, it means everyone that you want to be a beneficiary is assured they're going to receive something. How small or large the inheritance will be for them is up to you. you would decide on the amount of the percentage. So you might say 5% to the church, 5% to the XYZ charity. That leaves 90%, and you can say that 90% is to be divided equally among my living children. Now you've achieved the result you wanted, which was you were able to make some charitable donations and you were also able to leave an inheritance for your family. Nobody got cut out accidentally. So that's my number one tip for today. Use percentages rather than dollar amounts. Now, what if you have a beneficiary who either is a minor or they could be an adult, but you have some serious reservations on their ability to be financially responsible? You're concerned that once they get the inheritance, they might blow it. They might buy that sports car you heard them talking about or something else. So what do we have in our toolbox that we can use to achieve the result you want? Well, if we have a minor, you've got two options. We can either create a trust for that child that can last beyond their 18th birthday. And here's where you get to be very creative. I'm going to give you a blank canvas, a couple of brushes, and a bunch of paint colors. And you get to decide at what ages is this child going to receive some of their inheritance. No rules in the law, you get to make the rules. You could say at 22, you could say the next distribution at 25, and maybe the last distribution at 28. We can also, to try to encourage the child perhaps to finish their education, you might say they're going to get a certain percentage when they graduate from college or they graduate from a vocational program. Or you could even give the trustee the ability to distribute some money if that adult child wants to go into a business. And it's a very nice way of supporting their dream. So that's one thing we can do with children. Now, if you say, you know, Stephanie, I don't want to do a trust. I just want them to have the money when they're 18. Then we can do what's called a custodianship. So this is basically a bank account that can be opened at any financial institution. However, you want to understand when that child inheriting turns 18, they take their birth certificate to the bank to prove they're now an adult, and the bank must give them that account. They can't hold it back. But you have two options to choose from. Both are great options. Now, the trust will serve many purposes. So if you have that beneficiary you're concerned about that maybe needs some more life experience to learn how to be financially responsible, the trust is a great way to go, because it's like putting the carrot in front of the rabbit and encouraging the rabbit to take steps forward in order to get the carrot. So that's a great way if you want somebody to have a little more life experience. It's also very good if, let's say, you have a beneficiary that has had a known addiction problem, and maybe now they're in remission, they're going to a program, they have not been drinking alcohol or using drugs, whatever the addiction was. There's trust language we can put in that gives the trustee the ability to stop making distributions to that person if they suspect that they are using again. And the trustee can use the inheritance to encourage that beneficiary to seek professional help and to even pay for them to go into a program. So there's a lot of different ways we can be creative so that your estate plan is going to meet the needs of your beneficiaries. Now, how many of you have young minor children or perhaps grandchildren under 18? Let me see by a show of hands. So one of the things that Florida did a number of years ago is it created a new law that allows parents to designate a healthcare surrogate for their minor children. Now, why would we want to do this? Well, parents are at times going to take vacations by themselves, and they might leave the children with grandma and grandpa or aunt and uncle. So this document gives those people the temporary ability if the child gets sick, the child needs to, let's say, go to the pediatrician, go to the ER. It allows that person to temporarily make the healthcare decisions until mom and dad return. So this to me is a great tool, especially if parents have to do traveling because of their jobs. The other thing that's very good for parents to have when they have children under 18, as I mentioned, is to designate a guardian in writing. And so that's the person the court is going to give preference to appoint if the parent becomes either incapacitated or were to pass away unexpectedly. So believe it or not, we had a change 12 years ago in Florida's power of attorney law, but a lot of people still don't know that it happened or how it affects them. So since October of 2011, attorneys can no longer write a durable power of attorney that says it's going to come into existence somewhere down the road. So all powers of attorney since then are effective as soon as you sign them. Now, most of you, I'm going to guess, are at a point in your lives where you're still independent, you're handling everything, you're making all your financial decisions. And so you may be looking at me like I'm crazy saying, well, Stephanie, why would I want to sign a power of attorney now if you're telling me it's effective immediately? I don't want somebody else to just step in and take over. And I agree with you. However, an attorney can only have a client sign this document when you can still understand, when you can comprehend that you're giving permission to somebody you trust to handle your financial affairs if you're ill. So here's the key. Because it's effective immediately and because a photocopy by law is considered as good as an original, you don't want to give the original or a photocopy to the person you're giving the responsibility to. But you're going to tell them, I had this done, and if I'm sick, if I'm in an accident, if I'm incapacitated, this is where you can find the document because I've named you as my first financial decision maker. So what are the things we need this document to do? Well, let's think about what do we all do throughout the week. Maybe we do online banking, online bill paying, or we might still be writing checks. We might pick up the phone once every quarter and talk to our financial advisor. Hey, how are my investments doing? Is there anything you suggest that I sell or anything you suggest I buy? Well, if you think about it, those are all very private decisions. And because of the privacy laws in our country, somebody can't just call your bank up or your financial advisor and get information. The only way they can do that is if you gave them the power of attorney. It's a way of giving permission, but you're not making them an owner of your accounts or an owner of your assets. And that's a big thing that I want to distinguish here. So you're not adding their name as a joint owner to any bank account or an investment account, but it's a way of legally giving permission to get you through that time that you might be incapacitated. So my word of advice is if you don't have this in place, get it in place. If you have it in place, take it out, reread it, see when it was done, look at the names of the people that you named. Do you still want those people to make those decisions? Are those people still healthy? Are they still alive? But the key is we can only sign a power of attorney when we can understand. So timing is very important as to when we get this document in place. So we've touched on the fact that we should be reviewing our plan whenever there's a major life-changing event. But we also want to consider changing and updating the plan if the person we named as our fiduciary has died, they've become sick. Maybe we no longer have a relationship with them for whatever the reason is. So I'd like all of you after today to take out your plans, look at them, and open a dialogue. If you still have a relationship with the people you've named, talk to them, find out how they are. Do they still want to take on the responsibility? I have a lot of clients who will immediately say, oh, I'm going to name my oldest son or my eldest daughter. And I'll ask, why would you do that? Well, they're the oldest. Well, that doesn't necessarily mean they're the right person for those kinds of decisions. So you want to be able to match what is it that you need this person to do with the skills that they're going to need. You know, if somebody, for example, gets nervous about making healthcare decisions, you probably don't want to name that person as your healthcare surrogate, but maybe you want to name them as your power of attorney. Well, how are you going to know that? You're only going to know that if you talk with them, if you open up a dialogue and you ask them to honestly tell you, are you comfortable making this type of decision, taking on this kind of responsibility? It's much better to know that up front before the attorney starts to prepare the plan than to find out later on after you've already signed your documents. And then don't forget my tip. You always want to have at least one, preferably two, alternate people named, both to make the medical decisions, the financial decisions, to be trustee, to be personal representative. Now, if you find yourself in a situation where perhaps there isn't a close relative or a friend that you can name, you might want to consider naming a corporate fiduciary, either as personal representative or as trustee. You can also consider a corporate fiduciary if you do have children, you do have family, but you're concerned that if you name one of the three children, there's going to be fighting, there's going to be arguing. Why did mom name you and she didn't name me? Well, you take that out of the equation when you name somebody that's neutral. And so we can preserve relationships, we can preserve family harmony with that option. So when else would we want to update or change our plan? Well, if you come into a good sum of money, we might have to see what does that do to your tax situation. And I don't just mean income tax situation, because if you win a very large lottery, you might have what we call a taxable estate, meaning when you pass on, there might be an inheritance tax that Uncle Sam is going to charge. And there's ways to plan ahead for it to lower or eliminate that tax. So that's a reason why we want to reassess. You might have to also look at your retirement plan if you come into a large sum of money, or with that money, you might say to yourself, maybe I should purchase a long-term care insurance policy. That might be a financial source down the road if my health changes to help pay for care. So there's a lot of reasons for us to look at the situation when there's a change in financial circumstance. So let's talk about some mistakes, not that people intentionally make them, but they unintentionally make them. And what do we do to avoid making these mistakes? So On certain types of assets, we can name a beneficiary. We can do that, for example, on a bank account, CD. We can even do that on a brokerage account. What that means is when we pass away, whatever's left in that asset will go automatically to the person who is named. That person will produce their photo ID at the financial institution. What I want you to understand is if in your will or your trust you say everything I own, I want to be distributed equally among my children, but on one of the assets, you've already named one child, not three, one child as beneficiary. The result you're going to end up with is only that one beneficiary will get that asset. The will you signed or the trust you signed will not control what happens to that asset. So it's really important that you know, do I want everything to be the same? Do I want it to be a mirror? Or am I making this decision being informed? I know what I'm doing and I have a reason that I only want to designate one of the three people as a beneficiary of a particular asset. So I just want you to be aware of that and go into that being fully informed. Now, another problem you want to avoid is if you want to leave an inheritance for a child. Now, we talked about this just a little while ago. You don't want to just say, I'm leaving Johnny $5,000. And the reason you don't want to do that is because if Johnny is still under age 18, Johnny's parents are going to have to do a guardianship to hold that $5,000 until Johnny is age 18. So you either want to set up a trust for Johnny, like we talked about, or set up the custodianship. And Johnny will get it at 18, and then Johnny's parents don't have to go to court. Saves people time, saves people money, as well as privacy. Now, what if you want to leave an inheritance to a beneficiary and you know they have a disability? You know that they're getting assistance from a government agency. It could be Social Security. It could be the Medicaid agency. Well, you want to tell the attorney you're working with that important piece of information because then we're going to suggest that we write a special needs trust for that person's inheritance. So they still get the benefit of what that money can buy them to improve the quality of their life, the quality of their care, but because they're not going to be in control of the special needs trust, the government will still give them their Social Security benefits and their Medicaid benefits. So they get the best of both. But you do need to think about who you're going to put in charge as trustee of the special needs trust. And you want to also make sure you name an alternate person to be the trustee of the trust as well. Now, anybody here already have a revocable trust? Can I see a show of hands? Anyone? So what's important to understand when you have a revocable trust is it's not just, I've got the legal document, yay, I'm going to avoid probate, that's all I have to do. That is the first step. The second and just as important step to take is you need to name your assets in the name of your revocable trust. If the asset continues to be in your name at the time you pass on, your family or your beneficiaries are going to have to do a probate in order for that asset to get into the revocable trust. So an example I like to use is if you have a vase sitting on a table, the vase is empty until we pour the water in and we add the bouquet of flowers. Now the vase is full. It's the same with a trust. The trust is empty. It's just a legal document sitting there on a desk. It really doesn't mean anything until the assets are in the name of the trust. So it might mean that you have to go to your bank with the trust agreement and have them change the title from your name to the name of your trust. Or it might mean that if you have a life insurance policy, that you change the beneficiary to be your revocable trust so that all the assets are going to pour into that trust. So I hope you find that tip very helpful. So now we're going to debunk a lot of misinformation that you might hear from friends, neighbors, people you play cards with, golf with, or even things you hear on the internet. So how many of you have heard somebody say to you, oh, as long as you leave a person $1, they cannot contest your last will and testament? Let me see by a show of hands. How many of you have heard that? I probably have people asking me that question at least once or twice a week. Well, guess what? Leaving somebody $1 does not mean they don't have a legal right to contest your will if there's a valid basis. Okay? So if you don't want to leave a particular person anything because something has happened in the relationship, it's probably a better idea just to have the attorney clearly write out, I intentionally omit to leave anything to whatever the name of the person is. And we can either say, because they are financially comfortable in their own right, or we might say for reasons best known to them. But the way the law works in our country is the courts are open to redress any mistakes that have been made, anything that is not how it should have been. So if somebody was, let's say, not competent when they signed their will, somebody was under the influence when they signed their will, and somebody influenced them to do those things or to leave property just to one person instead of everybody else, the courts are going to be open to hearing that. So we can't avoid a wrong being righted simply by leaving $1 to somebody. Now, have you heard somebody say to you, I don't want to bother to create a trust for somebody under age 18. They've got disabilities. I don't want to mess anything up. So I'm just going to tell my personal representative to give money to that child's parents. Does that sound right to you? Yes? No. So we talked about the special needs trust, right? That's the right way to do it. That's the way of knowing and being assured the money is set aside for that child, and that child isn't going to lose their Social Security benefits or their Medicaid benefits. If you tell a personal representative, hey, just give some money to the parents, you don't know what's going to happen to that money. It could be gone. How about, have you ever heard somebody say, oh, I don't want my estate to go through probate. It's going to take years. Everything's going to be tied up. How many of you have heard of that statement? So that's also not correct. Now, you see I have a picture of Jacqueline Kennedy when she was very young. And the reason I have her photo up is because she is really the true reason why a probate might take a longer time. Jacqueline, after the president passed, was involved with a multimillionaire. And when she died, she was extremely wealthy. She was wealthy to the point where the value of her estate exceeded the level set by IRS. So her estate had to file what is called an estate tax return. IRS can take up to 18 months to review and audit the return and either come back and say, we agree with the calculations, or we disagree and this is what you owe us. So really, only when somebody has a taxable estate do we see situations where a probate might take longer than, let's say, 4 months. But that is not the average situation. So understand, if somebody has a taxable estate and is at that level of wealth, it's going to take longer for that reason, but that is not the norm. Okay, so it is not unusual when people are in second, third, or fourth marriages to think, I don't need to leave anything to this person. They're not my first spouse. You know, we came from different places. We each have some money. Well, you can't disinherit your spouse in Florida. And if an attorney were to write a will and not leave anything to the client's surviving spouse, the law is automatically going to give them 30%. Now, you can choose any number between 30 and 100. It just cannot be less than 30%. So remember what I said in the beginning. You can work with your spouse, go to a family law attorney, and have an agreement written either before getting married or after getting married that will determine whether you're each waiving all your inheritance rights or perhaps setting a different kind of number. But as long as it's agreed to, as long as you've had legal counsel, then the 30% requirement will not be applied. So how do we get started in this process? Because I want you to leave here being energized, being motivated, at least walking away with something you didn't know before. And my first suggestion is get the documents out, see who you named. Have that discussion with the people you named as your decision makers. Look at who you named as your beneficiaries. Do you want to alter either who the beneficiaries are, or perhaps you want to now change dollar amounts to percentages like we talked about? So does it need to be updated? Is there perhaps a new grandchild that was born? Did your adult grandchild get married? There's a lot of different reasons to update your documents. And remember, if you've got a child under 18, or perhaps your adult child has a child under 18, you want to suggest to them that they designate the surrogate and designate a guardian for the children. And if any of you have a child or grandchild that's approaching their 18th birthday, it's a good time before they go away to college or they enroll in the military for them to have some basic documents in place. So while they're away, if they get sick, mom and dad, or perhaps an adult sibling, will be able to make their medical decisions. And so when you're selecting an attorney, you want to ask, how much of your practice is spent doing estate planning? You don't want to work with somebody who dabbles. Maybe they read the statute last year, maybe they didn't. You know, it's much like medicine. In medicine and in law, we specialize. There's no longer that general practitioner. So if you've got a heart issue, you're going to be looking for a cardiologist. You're going to want to probably look for somebody who is board certified in cardiology. They've gone that extra mile in their education process to know that they are specialized. If you're in a different part of the state of Florida, a great resource for you would be the Florida Bar, and you can go on that website to the elder law section and you can find a practitioner in your area of Florida. And here are just some suggestions of what you can ask. Ask, how long has somebody been practicing? What portion of their practice is devoted to doing this? Do they charge a consult fee? What do you need to bring with you to that initial meeting so they can give you the best recommendations possible. And you want to see, how was your initial customer service experience from the minute you talk to them on the phone? That will tell you, am I in the right place? So at this point, I want to open it up to questions. I'm hoping you all brought questions that you thought about in December during your holidays. You're welcome to unmute your microphone, or you can send a message through the chat box.
Hey, Stephanie, I've got a question. You are always so informative and present it in such a great way and understanding way. I really appreciate it. You did slightly reference about long-term care policies, and I know there's brokers that sell that, but are there any tips you can give us in purchasing a long-term care? I have a long-term care policy, and apparently, well, I know it's with Genworth, and apparently they're sort of going downstream a little bit. They're suddenly now rated as C plus, and they've given us an offer to diminish their benefits and get money back. There's been I think, a class action suit against them. And so I'm actually thinking about switching to something else, or like learn more about a hybrid.
Okay. A couple of suggestions I can make. There is a website for what's called the National Association of Insurance Commissioners. They used to publish a written piece about long-term care insurance. You might find something helpful on their website.
Okay. National
About
Association of what?
National Association of Insurance Commissioners.
Okay.
If you work with a financial advisor, you might want to ask that advisor if there's somebody in their brokerage house that specializes in long-term care insurance policies.
Mm-hmm. Okay. Okay, thank you.
Good question.
Mm-hmm.
Hi, Stephanie. I have a quick question.
Yes.
Thanks for your presentation. It was wonderful. Can you put your house in a trust?
So you can. Now that's going to depend on a couple of things. Number one, is there a mortgage? Because if there's a mortgage outstanding, we really want to get permission from the lender. We don't want to prepare a deed and put it in the trust, not tell the lender up front, and then the lender decides to call the entire mortgage due. So that's my first concern. We'd also want to see, who owns the house. Are there several people? Because, then we've got to get permission from any joint owners. We need to see, is there a spouse that owns it as well? But yes, it is possible.
Okay, thank you.
You're welcome.
Another quick question. Can anyone contest your will?
Any
If they're not in the
You
family?
know, like I said, the courts are open to redress any wrongs that have been done. Now, that is not to say that people don't find lawyers who are willing to take a case that's truly a nuisance, that doesn't have a true basis for it. And that's very unfortunate when that happens.
Okay, thank you.
Any other
Hey, Stephanie.
questions? Yes.
Yeah, Stephanie, hi.
Hi, Carol.
Carol Lamb here. Hi, and thanks so much for the presentation today. Having worked with you, I obviously just about 100% was familiar to me. But I do have another question. You spoke about a spouse having, regardless, if you leave them zero, they would automatically get 30%. Is a domestic partner in that same category, or is there any
No,
rules about domestic
no.
partners? Okay,
No, it is strictly you must have a legal marriage, not a domestic partnership.
gotcha. Okay, thank you.
You're welcome. All good questions. That's how we all learn. Any other questions? Again, you know, if you're shy, you don't have to unmute your mic. You can write a message in the chat box. All right. Well, I am so happy to see so many of you. I hope you had wonderful holidays. I hope that your 2024 is off to an amazing start. And thank you again for joining me. As I said, we'll post the recording next week, so you're welcome to access it at your convenience and share it with your friends and family. So have a wonderful weekend.
Thank you.
Thanks very much.
Yes.